today, employment law is really a form of contract law. And we really need to say, okay, what are some of the key things that we're looking at here? Well, from a legal point of view, probably the first and foremost issue that we need to concern ourselves with is an employee an employee? this is Honda Canada versus Keys. And just to refresh your memory on this, Keys had worked for Honda. He had he was chronic absenteeism. He had an absenteeism problem. And the reason he had an absenteeism problem is he had chronic fatigue syndrome. Okay, so he had a health issue. Honda was a little bit doubtful of that. So what they wanted him to do was to subject himself to a Honda doctor reviewing him. So Honda said to him, listen, you're off work too much. We don't trust your own doctor. We want you to look at our doctor. And Buddy refused. Okay. So Honda basically terminated him. That was the basic crux of the story. So Keys sued for wrongful dismissal. And the reason that the basis on which he sued was the fact that you really can't fire someone for being sick. So at the trial, the judge found Honda had a culture of a lean operation and production efficiency, which led them to hound Keys because of his absenteeism. It was also clear that by the judge that Honda thought Keys' condition was bogus, the very fact that they asked him to go to a Honda doctor. Honda representatives have tried to persuade Keys to reject the advice of his own lawyer and go to the doctor. Since these acts amounted to bad faith on the part of the employer, the judge in the original court, based on a precedent from an earlier case called the Wallace case, extended normal notice period. He had worked for 14 years, so usually it's the judge will look at it and say, well, you worked for 14 years, and it's about a month per year of pay that the judge would probably rule. And so extended the normal notice period 15 months by an additional 9 months. So he basically gave him 24 months of pay, lost pay for that. And that amounted to about $150,000. Further, the judge went on and said, listen, this has caused you so much grief, Mr. Keys, that I'm going to punish Honda and I'm going to award you $500,000 in punitive damages, and the fact that Honda was hounding you, and the fact that they didn't believe you, and the fact that they fired you. So the court, that's what the court ruled. So that was a $650,000 award. And then Honda appealed it. So it went off to the Court of Appeal, and the appeal court said, well, the findings on the wrongful dismissal and the award of extra damages were upheld, but the damages were reduced from $500,000 to $100,000. So basically, what he got was $150 plus $100, which was $250,000. That wasn't enough for Honda. Honda said, listen, this has implications for all of employees across Canada, and it has implications for all employers across Canada. So Honda petitioned the Supreme Court of Canada to review the case. So it went to the highest court in the land. And again, the Supreme Court took it because of the fact that it had some precedent-setting potential. So on further appeal, the Supreme Court of Canada rejected the practice of extending the notice period as a consequence of an employer engaging in bad faith in the manner of the dismissal. So effectively what the Supreme Court of Canada said, well, the judge should not have extended the period from 15 months to 24 months. So we're going to roll that back. Okay, so the court indicated the damages for the manner of the dismissal will only be available if the employer has acted during the course of the dismissal in a manner that's unfair and in bad faith by being, for example, unfaithful or untruthful, misleading, or unduly insensitive. So such damages should be awarded through an award that reflects actual damages, not by extending the notice period. So the Supreme Court set aside the award of aggregated damages on the basis that Honda's conduct in dismissing Key was not an egregious or outrageous display of bad faith. So the Supreme Court basically said Honda didn't do anything wrong here. They didn't do anything in bad faith. So they basically rolled back that award too. Further, there was no evidence that Key's subsequent disability was caused by the manner of his termination. So punitive damages were also set aside. For even though they were awarded for deliberate wrongful acts that are malicious, Honda's behavior, although insensitive, was not deserving of this punishment. So basically, Honda was vindicated here in this by the Supreme Court of Canada, where they basically said, look, Honda, even though it wasn't necessarily ethically good what they did, it was certainly not legally good. So all this proves, seeing it went to the Supreme Court, and the Supreme Court basically sets the standard for the law, is that, this idea of a judge potentially awarding additional damages beyond the basic award that you would get for however many years, the basic rule of thumb we've talked about when you get wrongfully dismissed is that they will effectively be asked to pay you, the employer will pay you 1 month of wages for every year you've worked. So basically that's what the Supreme Court came back to and said, look, there's no indication of punitive damages here, so they wiped them out. That was $500,000, which got brought down to $100,000, which got brought down to zero. So Mr. Keys was without a job, but he did get 15 months worth of pay. The other, we talked about wrongful dismissal, and a version or a derivation on wrongful dismissal is something called constructive dismissal. And in fact, constructive dismissal happens quite a bit, and it seems to be something that might be permeating into our world more than it ever was, as employers are forced to change, for example. So by effectively, constructive dismissal is when you are effectively pulled out of your job, or your job is taken away from you by some effective demotion, transfer, or otherwise changing conditions of employment, where an employee may be made so uncomfortable that he or she will quit. Now, I can imagine, just think about the college system. If someone who's not too computer literate or not very comfortable with computers right now, and this is something the government is certainly going to find itself in, where we have people who are not at all comfortable going online, and they're forced to go online. And if they quit or they leave the employ of that, I wouldn't doubt we're going to see some case crop up in the next little while where someone said, well, I'm not doing this, and they effectively sue for constructive dismissal because their job changed so fundamentally that effectively it was no longer their job. So under constructive dismissal, an employee can sue for wrongful dismissal if it can prove that the conditions changed so much that it effectively changed the job, okay? So the employee's obligation is to mitigate any of the damages. So, the employee is expected to go out and look for a job somewhere to be able to reduce the damage to himself by looking for some alternate employment. And the employer should communicate with employees and try to identify an appropriate arrangement, which is what government is trying to do now with a lot of teachers or instructors at the college or anyone who is put into an uncomfortable situation that they're in. So here's a good case for constructive dismissal that certainly kind of sets the standard in Canada right now. This is another case that got pushed all the way up to the Supreme Court. So this is the test for constructive dismissal. Okay, what exactly is constructive dismissal? Here's what the court has said on it. When can a non-unionized employee who's suspended with pay claim to have been constructively dismissed? The traditional test of constructive dismissal is whether a unilateral or fundamental change to the terms and conditions of employment have been made. Here, the Supreme Court of Canada articulated a new second test that also determines whether a constructive dismissal has occurred. So Mr. Potter, was to serve as an executive director of the New Brunswick Legal Aid Services Commission for a 7-year term. But his relationship with the commission deteriorated to the point where the parties began to negotiate a buyout of the plaintiff's employment contract. So this guy Potter had gone to work for the New Brunswick Legal Aid Commission. He had signed on for a 7-year term, but the relationship fell apart, and basically they had started to talk about, well, okay, we're going to let you out of your contract, and Potter and the Legal Aid Commission were kind of negotiating some sort of I call it a golden handshake. He was ready to leave, and he was going to get some money for doing it. Potter went off on work on sick leave, and the commission subsequently suspended him indefinitely with pay and delegated his powers and duties to another person. So he didn't get pulled. His pay wasn't pulled, but he was pulled away from the job, and there was no real end in sight. Later that day, the commission recommended to the Minister of Justice that Potter's employment be terminated for cause, but Potter was unaware of this. Instead, Potter commenced an action claiming he had been constructively dismissed. The commission responded by terminating his pay and benefits, claiming that the commencement of litigation was equivalent to a resignation. So, overturning the decisions of the lower court, Supreme Court of Canada found that the plaintiff was constructively dismissed. The court clarified that the test for whether an employee has been constructively dismissed consists of two branches, and a claim for constructive dismissal can be proven through either branch. The first branch involves situations where an employer imposes a unilateral change to the contract terms, which is basically the standard approach that we've talked about. This change must be found to substantially alter the essential terms of the contract. If a reasonable person would view this breach as substantial, the employee has been constructively dismissed. So if any third party looking at it would look at it and say, yeah, that's a pretty big change, then effectively it's constructive dismissal. The commission acted unilaterally when it suspended the plaintiff, and there was no express or implied grant of power in the employment contract to suspend for administrative reasons. Further, it was reasonable for the plaintiff to perceive that the unauthorized unilateral suspension was a substantial change to his employment contract. As such, the plaintiff was constructively dismissed and entitled to damages for wrongful dismissal. Okay, so effectively they changed the job on him, or they did something that made it so impossible for him to continue that they said, yeah, you're constructively dismissed. The Supreme Court, though, in this case also introduced a second test, where it can be shown based on the employer's cumulative actions that the employer did not intend to be bound by the employment agreement. The employee has been constructively dismissed in this case. The test is an objective one. Would a reasonable person in the same circumstances as the employee conclude the employer intended to no longer be bound by the employment agreement? The very fact that they were in negotiations for addressing the deteriorating condition and get rid of them indicated that that was indeed the case. Under the second branch, employees can argue that they have been constructively dismissed based on the past acts of their employer that, viewed objectively, demonstrate an intention not to be bound by the employment contract. So an employer has to be very careful here whenever they change the basic rules of the game of employment. And if the rules change so egregiously, someone could argue that they're constructively dismissed. Or if there's a good indication that to the employee that the employer is getting rid of them anyway, they've made overtures to get rid of them, then effectively that would be constructive dismissal too. Now, effectively, what does this mean? Well, it means that the employer would have to pay compensation for approximately 1 month's salary for every year of work. So those situations, wrongful dismissal, constructive dismissal, are very much from the employer's perspective. Okay, the employer is getting rid of. Well, what happens when the employee decides to get rid of the employer? The employee decides to quit. So employees are bound with the exact same rules as the employer. For example, if you are to leave your place of employment, you are obliged to give them notice. No different than they are obliged to give you notice. So employees may quit for cause. Now, if there's cause, is a different situation. So if they're what are some of the cause? Given dangerous or illegal instructions, not properly paid, put in dangerous situations, can no longer perform duties due to a disability or illness, or an important term of the contract was breached. Now, this is where we get a fundamental breach in the contract, right? No different than from an employee being fired because they broke the basic tenets of the contract. They did something so egregious. Same thing here, an employee can leave if the employer does something so egregious. The contract may provide for notice. So if you and I are employer-employee, we may have written in your employment contract that you have to give X number of weeks notice, or I have to give X number of weeks notice. Okay, it could be written in the contract. Now, legislation is in place by the Labor Standards Act that specifies that if I've been there any length of time, I have to give you a week's notice, 2 weeks notice, 3 weeks notice, depending on how long I've been there. Okay, the time frame really depends on the length of employment. So if there's no contract, you must give what's called a reasonable notice. This is what's laid out in the basic term. So usually much less than the employer is required to give unless the employee has a special role in the business. So, there is still an onus on the employee to make sure that they give some degree of notice. And you could be held liable for wrongful or inappropriate conduct when leaving. So, if the employee does something like spray paints the wall, say this employer sucks, something like that. The employee, and this is one of the real catches, and this is where problems often run. We've seen several examples of this, where the employee cannot take confidential information, customer lists, secret formulas, or practices when they leave. They cannot persuade customers to accompany the employee to a new business, and they must comply with restrictive covenants in the contract if the restrictive covenants are reasonable, okay? And we've already discussed the idea of restrictive covenants and whether or not they're reasonable. But this really puts an onus on the employee to ensure that they don't get caught doing something they shouldn't be doing. They shouldn't be taking confidential information. They shouldn't be taking customer lists. They shouldn't be taking secret formulas. And in this day of computer technology, it's so easily done. I mean, your odds are you're going to have access to confidential information in your place of work. And seeing it's all electronic now, it's very easy to take it. So you could get caught up legally, that is, if it's found that you had access to some of these things and took them. Here's an example of a case of an employee that had to give a long notice, and it really depends on the job. Savoy and Derringer were employees of Tree Savers, a relatively small company working in the oil industry. After giving Tree Savers management 2 weeks notice, they left and incorporated a company in competition with Tree Savers. How often does that happen, right? So Savory and Dillinger had been key employees, which is an important part of Tree Savers. And when they left, they took some documents with them, including lists of contacts. DeCarm, who had given them financial aid and advice, and the company they created, Trojan, was also defendants. The court had to decide whether Savoy and Derringer were in violation of their fiduciary duty to their former employee. And the answer, according to the court, was yes. An injunction was issued ordering them to stop the offending conduct. The Alberta Court of Appeal decided that because the two men were senior key employees, they should have given their employer 18 months notice, and damages awarded were calculated on this basis. DeCarm was also found liable for inducing them to breach the contract. So here we got an interesting situation where two of these people were key employees, and they were such key employees that they really were the lifeblood of the company. And when they left and formed another company in competition, that was a real problem, particularly when they took key information from that company in order to start the company. And also the accountant that they hired, or the lawyer accountant, whatever his name, DeCarm, who gave them some advice and financial aid, was also held responsible because he induced them to do it. So again, you got to be very, very careful. And the real philosophical problem that comes of this is, how in the heck can someone tell you what to do once you leave their employee? If you're a person and you work for someone, you leave them, you got to be able to make a living, And odds are it's going to be in the field that you worked in, which is probably potentially in conflict with your former employer. So there is kind of a balance that the court has to strike between allowing a person to make a living, yet at the same time being respectful of their former employer. So here's a case that's very similar to this. So there's no general duty not to compete with former employer, RBC Dominion Securities versus Merrill Lynch. Two of them are security companies. They sell stocks and bonds, that sort of thing. Virtually all the investment advisors at Cranbrook RBC branch left without notice. They went to the branch of a competitor, Merrill Lynch. Dallamont, the RBC branch manager, orchestrated the move. RBC sued Dallamont, the departing investment advisors, as well as Merrill Lynch and its manager. So, it's pretty bad that your branch manager at the RBC office was the one that kind of got everyone to say, hey, let's quit this crowd and go over with the other crowd. So RBC sued, and the departing investment advisors and the branch manager were sued, and Merrill Lynch, who hired them, were sued. The trial judge held that, one, Dallamont and the investment advisors were not fiduciary employees, and two, the investment advisors breached the implied terms of their employment contract, requiring reasonable notice and prohibiting unfair competition with RBC, and three, Dallamont had breached his contractual duty by organizing the departure. Damages were thus assessed against the investment advisors and Dallamont. Because the Merrill Lynch manager had induced the breach of contract and the duty not to compete unfairly, Merrill Lynch and his manager were found jointly and severely liable as well. So then it went to the Court of Appeal, and they varied some of these damages, prompting a further appeal. The Supreme Court of Canada reinstated the award of the trial judge, except for the damages payable to investment advisors for RBC's losses during the notice period. An employee who has terminated employment is not prevented from competing from his employer during the notice period. RBC was restricted to damages for the employee's failure to give reasonable notice, $40,000 for the employee's failure to give 2.5 weeks notice. Damages for breach of contract should cover losses that arise naturally from the breach, or as may reasonably have been contemplated of both parties as the probable result of the breach. An implied term of Dallamont's employment contract was his retention of RBC's employees under his supervision. And Dallamont therefore breached his contractual duty of good faith by organizing the departure of the advisors. For this breach, damages were calculated to be $1,483,239, being the loss caused to RBC projected over 5 years. So you can see that there was quite a stiff penalty imposed on those people who basically up and left and went over to the competition. There also is another situation that could arise too. We've talked about wrongful dismissal. We've talked about the idea of constructive dismissal. We've talked about the obligations that come from these various dismissals. But what about hiring? And what if we had a situation where someone got hired when they shouldn't have? Well, effectively, how does that happen? Well, the fact of the matter is that wrongful hiring exists when the employer induces an employee to join the employer based on misrepresentations of job duties for the position. So effectively, wrongful hiring is from an employer point of view, if I were to offer you all kinds of verbal perks to come to my company, and you left your company to join my company, and then I didn't give you those perks, that would be considered as misrepresentation on my part, the employer's part. So wrongful hiring is based on the tort of negligence or fraudulent misrepresentation. So an employer should not overstate the importance or the status of the position. Employees accept positions based on the description. And if the description is brighter than the actual job, that could create a problem. So in order to bring lawsuit against for wrongful hiring, the employee must show that reliance on the misrepresentation when making the decision to accept the employer's, you basically relied on them, and the employee must have suffered some sort of a loss. So, we've got a good basis here for a cautionary for employers when you go to hire someone. Make sure you're realistic and people understand what they're getting into. Okay. Then we also got this liability to third parties. Someone basically gets caught in the situation because of someone got fired, wrongful dismissal, whatever. So we got this issue of vicarious liability here, and the liability of an employer for acts of his employees. We talked about that before. We've talked about this idea of business being carried out by the employee on behalf of the employer. So we really need to ask ourselves, when is the employer liable? Well, the employer is liable for the acts of his or her employees if we got negligence going on there or there's some sort of breach of contract. So the test is the general rule with respect to the third-party liability is that the employer may be held liable for any losses or damages suffered by a third party as a result of an employee's failure to perform a contract in accordance with the terms, for any negligence on the part of the employee acting within the scope of his or her employment that causes injury or loss to the third party if within the scope of the employee's job. So we had a situation, for example, let's say North Atlantic Petroleum. I hire you as a propane fitter. You come into a house, you hook up the propane, and you forget to tighten up something, or anyway, there's a leak. And because of that, there's an explosion and a fire, and the house is damaged. Here's what we got going on there, and the question is, who's liable? Well, in this case, the employer will be liable because it happened during the course of the employment and what the employee was normally supposed to do. And the basic reasons for this is the employer tends to have deeper pockets than the employee, and the fact is that it is part and parcel of the organization. They get that sort of thing, and usually what employers do is, or what they always do, is have insurance to cover that sort of thing. Employer liability is limited only to those acts where the employee falls outside the ordinary scope of the employee's duties, right? So if it's beyond the scope of duties, the employee is responsible. Okay, so that effectively is that first section, and that first section really we've looked a lot at all of the things dealing with coming to work and setting up shop at work, potential leaving work, and what happens when you do leave, and under what circumstances you leave, and the obligations of both the employee and the employer under those things.